Item number 10 is the proposed changes to the VMC. This is an ordinance of the City of Vancouver expanding the definition of public disturbances to restrict certain additional noises and vibrations, expanding the definition of pedestrian interference to prohibit targeted picketing or protests, and allowing the city to assert a claim or lawsuit on behalf of an official, employee, or volunteer to the extent it is reasonably necessary in order to further a public purpose, amending Vancouver Municipal Code sections 7.05.010 public disturbances, 7.04020 pedestrian interference, 7.04030 definitions, and 2.46.020 defense of officials, employees, and volunteers, providing for severability and setting an effective date. Staff summary, please.
Thank you, Mayor and Council.
Lean right into that microphone a little bit stronger. Thank you, Ms. Dollar.
Good evening, Mayor, Council. My name is Nina Cook. I'm the Chief Assistant City Attorney. May we go to the next slide, please? Tonight, we're here for your consideration on an ordinance that proposes changes to 3 chapters of our Vancouver Municipal Code. We'll discuss each of them separately, but in general, the ordinance revises Chapter 7.05 to expand the definition of public disturbances to include some additional noises and vibrations. The second thing it does is revise Chapter 7.04 to expand the definition of pedestrian interference to include targeted picketing and protesting. And the third thing it does is revise Chapter 2.46 to assert a claim or lawsuit on behalf of an official, employee, or volunteer to the extent it is reasonably necessary to further a public purpose. Next slide, please. The first change to VMC 7.05010, the changes do 2 main things. First, they add noisemakers that are listed there to the list of sounds that are regulated in residential districts. Second, they add vibrations or infrasound to the list of what could constitute a public disturbance. I think it's also important to point out what this proposed change does not do. It does not prohibit the use of noisemakers in commercial or mixed-use districts as defined in VMC 20.430. It doesn't prohibit them in industrial districts defined in 20.440, nor does it prohibit those noisemakers in open space districts defined in 20.450. In addition, the changes do not prohibit these noisemakers at permitted events or in the public square. Next slide. This portion of the proposed ordinance aligns VMC 7.04020 and 030 with the 1988 U.S. Supreme Court case of Frisbee versus Schultz. That case prohibited picketing and protesting in one place only, and that was, to use the words of the court, quote, before or about the residence of another person, end quote. This proposed ordinance uses the exact language the U.S. Supreme Court found 35 plus years ago as constitutional. In that Frisbee case and in the cases that have come down since, the Supreme Court has consistently held that regulating speech is permissible if the regulations are narrowly drawn and tailored in time, place, and mannered, and balanced against compelling government interests. It's important to note that the constitutional protection of free speech in the First Amendment is not absolute. It has never been absolute. It is always based on a balancing test. So let me just give you the example that we hear in law school all the time. Courts balance my right of free speech with the government's compelling interest to protect others from my speech. which is why I can't go into a crowded movie theater and yell fire. I do not have a First Amendment right to free speech in that case because my right to freely speak or yell fire must be regulated, and in that case actually prohibited in light of the compelling government interest to protect others from my speech, from the panic that would ensue as a result of people racing out of the movie theater to try and seek safety. And indeed, that's what the court in Frisbee did. There, the court held that the government has a compelling interest in protecting the unwilling listener from unwanted speech when the listener is in the privacy of their own home. The court held that picketers outside of one's home, they don't seek to disseminate a message to the general public, but instead intrude upon the peaceful enjoyment of one's home. That ruling still allows protests. It just restricts the location of where those protests can occur. So that is the balance the 6-3 conservative majority held in that case. They held as unconstitutional targeted picketing and protesting in front of the residence of another, but still allowed protests and picketing in the public square or out front in front of our city hall. This proposed ordinance strikes that same balance, and in so doing leaves VMC 7.04040 sub 1 unchanged. That provision still allows individuals their constitutionally protected right to legally picket or protest. This third change in the ordinance, proposed changes to 2.46020, goes beyond defense and indemnity of an official, employee, or volunteer. It empowers the city to take affirmative action on behalf of a person. It would allow the city to do things like seek a restraining order or an anti-harassment order against an alleged perpetrator, or an order of removal of or otherwise known as a removal of trespass of an unauthorized person. This type of affirmative relief would further a fundamental public purpose of government so as to not run afoul of the gift of public funds doctrine, which prevents the city from using money or resources to aid any one individual. Happy to address any questions or any discussion.
All right, thank you. Councilors, questions? None at this time. Thank you.